would go to like Texas stop in another one. But now there's no need. You just get it here. Yeah. Like, have you had buddies already? Customers? I feel like they're similar to him. Mm-hmm. But I don't think well, I guess sometimes it's rare and they need us to cover, or you guys cover us. I think when you're on your own, you'll get your own groove. Like, they know it's like scared. I don't know what I'm doing. It's like too much. But they just they know they're going to yes, they have that. When I first started, I wouldn't even like use all like the keys. I would just like make it like a space, and then I would go back and fill it in later. Mm-hmm. But that I was on island, that takes like way too fast. Wow. She's oh, you met her, right? Yeah. Yeah, they most some of them sit over there in the corner. Where, like some of the civil monitor. Heard that? And stuff like that complain about like monitor. Oh, somebody we got told not to like talk like that, not too loud. Like writing, that kind of going with kind of ensuring nothing. Oh yeah, they're clerks. I started with the two guys for the things next to me. Oh, this guy. Yeah. I started playing on the same team. Oh, I see this guy. Oh yeah, they got weird. Like I changed. Or yeah, they did update on the machine. Did you like retake your machine? That'll be on there forever. You know how like when you click on the ones you call them. I guess for a while until they get until like more people come in and they just stop. I feel like I would not. I feel like oh.
Good morning. This is Judge Daniel Ramsick, Second Judicial District Court, Division 6. The court is calling the 9:45 a.m. matter of Keeton versus New Mexico Racing Commission et al. This is CB 2025-2345. Could I have appearances for the plaintiff, please?
Joseph DeAngelis for Toby Keeton.
Mr.
And
DeAngelis.
Blackburn is hopefully joining us later. He's in another hearing right now.
Okay, Mr. DeAngelis. Good morning, Mr. Blackburn. You want to go ahead and state your name, please, for the record?
Oh,
Yes, Your Honor. Can you hear me?
Yes.
Billy Blackburn on behalf of Toby Keeton, Your Honor.
Okay, good morning. And who do we have here for the defense, please?
Good morning, Your Honor. Eric Lohman on behalf of the defendants.
Mr. Lohman, good morning. And do we have anyone else present who has not identified himself or herself for the record? Okay. All right, so this is a status conference. Mr. DeAngelis or Mr. Blackburn, you guys want to bring me up to speed, please? Where are we?
I believe we filed with our motion update of what's been going on. This litigation has sort of a complex posture because it's really happening in two different states. It's happening in New Mexico and in Texas. We are currently in negotiations with the New Mexico Racing Commission to figure out if there's a split laboratory available in England. Mr. Lohman might have some update for us, hopefully, on that. We haven't heard from him in a couple weeks. Once we get some clarity on that, I think that was sort of our last shot on finding an alternative split sample laboratory. And once we have an answer to that, our plan is to file an agreed motion with the New Mexico Racing Commission to set a hearing on the merits, and move that forward. And hopefully, and because we have discovery rights in that proceeding, our plan was to conduct discovery on the underlying administrative matter and the open records matter at the same time, so that we wouldn't have to depose people twice and there wasn't any question about what was relevant where. Thought that was the most efficient way to move forward. So we're just waiting to hear back from Mr. Lohman before we take the next step. And I don't know if Mr. Lohman has an update for us.
Okay, what, if anything, are you, Mr. DeAngelis, asking the court to do today?
Nothing today. We had no objection to a scheduling order or just holding the matter in abeyance until we get hear back from the England laboratory on whether they can split sample laboratory.
Okay, Mr. Lohman, what is the status of this matter from your perspective?
Don't know that I disagree with anything that Mr. DeAngelis just said. I might quibble with some of the characterizations in the motion to reinstate, but I think we're mostly on the same page this morning. So the English lab, the lab in England, is interested in doing the split sample testing. We would all like that lab to do the split sample testing, but it needed to communicate with industrial labs, which is the original lab that did the first test that had the positive results. And because there have been arguments in this case and issues in this case about labs communicating with each other, I wanted to make sure that the parties were on the same page before we put those labs in touch. I think we reached an agreement with the plaintiffs a few weeks ago, maybe a month ago or so on that. My understanding is I'm not privy to the communications between the two labs, but my understanding is that they have communicated. They've talked about what documentation they would need from each other. And as far as I know, the labs are communicating, and we are waiting to hear back from the lab in England about whether they have the ability to do this testing for the substance abuse levels.
So we're still talking about split sample testing. Are we still talking about that? Is this, you guys, this seems like it's been going on for quite a while. And it reached a point where nothing was being done, so I dismissed the complaint. And then, of course, you guys moved to reinstate it, which I have no problems with. But this is getting kind of silly. Let me look at the The original complaint was filed, well, not too long ago, but still March of 2025. And if I'm understanding correctly, we still don't have any definite word on a lab which is going to do the split sample testing. Mr. DeAngelis, is that correct?
That's correct.
Okay, and
what
Mr.
we-
Lohman, is that correct?
That is correct, Your Honor.
All right, so
Could I
the split
clarify
sample, no, I don't want a bunch of explanations. I just need to know there's no split sample testing lab ready to do the work yet. And so, Mr. Danges, I'll go back to you. When do you think you will have this sample tested?
The issue is that,
I know what the issue is. Believe me, I've heard a lot about this. When do
sure.
you believe the sample will be tested so you guys can get
Oh.
this matter resolved, or I can set it for a hearing?
Oh, sure. I anticipate that if England can do it,
When?
probably it would take about a month after they accept the sample for them to get a report out. If they can't do it, I think we've exhausted all the possible laboratories that could do the tests, and so
Okay, and then
Lowen
what
and I
would be
would
your
be.
request at that point? Because so far I haven't seen any lab stepping up to do this. So if a lab doesn't do the sample, what are you going to ask the court to do then?
Mr. Lohman and I were going to we've been in conversations before about if there are no available split sample laboratories, we would probably file a motion with the stewards to dismiss the underlying matter, and
Okay,
work that way up through the administrative
okay.
process
So
before.
how much time do you think you guys need to get this? I mean, you just call the lab and say you're going to do it or not. Here's the sample, test it. How long do you think that's going to take?
Um, for the split sample, I'm not in control of that timeline. Mr. Lohman has more control over that than I do. But my hope is that a month is when we get that done.
Okay,
Um,
Mr. Lohman, do you agree? Can this sample finally get tested within the next month or so?
I would like that to be the case. I don't know that we can commit to that, Judge. We're still waiting to hear back from the English lab about whether they have the ability to do it. And it's,
Well, when did you guys approach this English lab? How long
we've been,
ago?
we've been discussing,
Not
we
discussing,
originally,
you just call them and say, we have this sample that we've been waiting
well,
almost a year and a half to get tested, and then they say yay or nay.
well, it's not that simple though, Judge, because this is an emerging area of the science. This is
Well,
new
either
for us.
they can do the testing or they can't. That in and of
Well,
itself is pretty straightforward. And
well,
why don't we do this? Yeah, I don't mean to be disrespectful. It's just we keep having the same conversation about this and it's getting a little old. Actually, it's very old. So why don't we do this? Why don't Mr. DeAngelis, to your knowledge, is this a bench trial?
yes, it'd be a bench
Okay,
trial.
all right. And when do you think this matter will be ready for trial?
All we need are a couple depositions, which we could do within the next 2 months. I'd say that this would be ready for trial within 4 to 5 months.
Okay, Mr. Lohman, do you agree? What is your assessment?
I think that's a little quick. Um,
When do you think it will
there's
be
not
ready for trial?
Yeah, I don't think we've done written discovery yet. I know there's been one round. I would say at least 6 months, Your Honor.
Okay, and Mr. Lohman, how many days for trial? 1 day? 2 day?
Um, in a bench trial, I would think at least 2 days. There's also this IPRA issue that's kind of, I don't want to say a
Okay.
tag along issue. I don't know if that, well, there's also an IPRA claim, so it might bleed into a third day.
Okay. I'm going to set for a 2 day bench trial in January of 2027. I want to warn the parties well, no, we'll just do that. There won't be any motion for dismissal for lack of prosecution because we're moving toward a trial. So 2 day bench trial, January 2027. My assistant will send out the notice. If you have any scheduling conflicts, let me know. We'll work around your schedules. What I'll need is for you guys to prepare a scheduling order. And what I would use is January 1st, 2027 as the day to work backwards from in terms of your deadlines. Whatever deadlines you agree upon are fine by me. Scheduling order to be submitted. And the only deadline I need you to include in the scheduling order is findings of fact and conclusions of law and a written opening statement. Those proposed findings, conclusions, and written opening statement will be due to the court no later than December 15th, 2026. That'll give me a couple weeks to get up to speed. And so if this proceeds to trial, we just jump right into the plaintiff's first witness. We just go right into it. So that helps me a lot. And then, of course, after the trial, you guys can submit supplemental findings and conclusions. If it looks like the split sampling testing is not going to get done, then it sounds like the parties may be in a tentative agreement that the commission's decision will probably be set aside, but I don't know. And I'll let you guys decide that. So I don't need to hear from y'all again. I'll see you for trial in January. Obviously, if you have any substantive motions, get those filed as soon as possible. If there's anything I can do to help you, just let me know. But it sounds like this testing that is critical to the case is has not been accomplished yet. And I'm not suggesting it's because of any dilatory conduct on the part of the attorneys. It sounds like, from what I remember, you're having a hell of a time finding a lab to do the testing. So at some point, you're going to have to make the decision, can you get the testing done or not? And if you're not going to be able to get this testing done, then you got to figure out where you're going to take this case. So I think that's it. Mr. DeAngelis, can you think of anything further?
Nothing further, Your Honor. Thank you.
Okay, sure. Mr. Blackburn, anything further?
No, Your Honor, I take it then that the trial will be scheduled on the 4th and the 5th, that first week of January. That's that Monday and Tuesday? Or,
I don't know what my schedule looks like
Okay.
right now. My assistant will check, and then I'll have him call your offices.
I
make
have
sure
no
that-
problems with that. I just wanted to make sure it was that first week.
Yeah, absolutely.
Okay.
Mr. Lohman, can you think of anything else?
No, Your Honor. Thank you for your time today.
Yeah, you're welcome. Mr. Blackburn, I have a neighbor. Her name used to be Catherine Hammer. Now it's Catherine Davis, Kate Davis, and Dennis Davis. Dennis,
Yes.
unfortunately, passed from a heart attack. But Kate and I were together at Highland High School back before cars were invented. She was a year ahead of me, and she mentions a lot of the Greeks and sorority sisters, and your name pops up every now and then. She goes, "How is Billy doing?" Just fine. Just we're both still alive. Is there anything more you need to know? And but anyway, Kate said if I ever saw you again in court to say hello. So she sends her hellos.
Well, Your Honor, it was interesting. There was a function I went to this weekend that included people I haven't seen since I graduated from college, but they all remembered some of those stories from those fraternities at the time.
That's the
And-
danger. Yeah. I'm
Yes,
supposed
and I had to
feel free to share.
confess, that I was president of one of those particular deals, and some of the first pledges that I dealt with was Rudy Chavez and Tom Clear. Go figure.
I will remain judicial, and yeah, I'm going to my 50th reunion for Highland, and I don't think there are that many of us still alive. But
Well, she
anyway,
came all the way from Santa Clara, California, did she not?
I think her family was military, and then she ended up
Yes.
at Highland, and then yeah,
Yes.
it's a small world. And Mr. DeAngelis and Mr. Lohman, thank you for putting up with our memory lane. But I did promise Kate Davis that I would say hello to Mr. Blackburn for her. So thank you all very much.
Thank you all.
Guys have a good day.
All right. Thank you. Bye-bye.
Take care. Bye-bye.
You seem to be doing better than you were the last time I saw you.
Go away.
Go away. Will you give me just a few more minutes?
No.
Please.